This action is styled State of Ohio Plaintiff versus George Washington Wagner IV, defendant, case number 2018 CR 155. We're having a hearing today. Today is the 31st of August, 2022. A jury view of some of the premises or things allegedly involved in this case is scheduled for today. We've convened here. We received some correspondence from Mr. Greiner, I believe it was. So, Mr. Greiner, do you wish to address the court and parties here and indicate what it is that you are requesting?
It was our understanding that there was some indication that the media would be not permitted to attend the view along with the jury. We cited to you the case of State of Cincinnati Enquirer versus Bronson, which indicates that the jury view is part of the trial proceeding and that there is a presumptive right of access by the press and public to the view that can only be limited if the court finds that closure is essential to preserve a higher or overriding interest and that closure is narrowly tailored to serve that interest. And the court is required to have a hearing on this matter, and I appreciate that you're doing that, and make findings on the record. And we're not aware of any overriding interest that would require closure of this event. We obviously, the court can put some limitations on it. We don't intend to intrude at all. The representatives of the media who are here would do what they're doing right now, which is observe from a distance and just be able to see. We'd like the opportunity to record it in some form or fashion as well. And we think that we don't see any risk of an unfair trial or any other overriding interest that would require closure of this event today. This is a part of the trial. The trial is open to the public, and we think that that is an appropriate approach and that the media should be permitted to attend. Thank you.
Thank you. Mr. Owens, you are here, I think, as a representative of one of the landowners involved, so do you wish to address it?
Yes, Your Honor. James Owen on behalf of Frederica Wagner. Your Honor, before you get to the issue of closure and weighing of interest, the first issue under Bronson is whether there's a qualified right of access that attaches. And a qualified right qualified right of access only attaches if two conditions are met. One is that the place and process have been historically open to the press and general public. Ms. Wagner has been at the premises that the court intends to view on Thursday for decades and decades. It's always been gated. There are no trespassing signs, and it's not been open to access at all. The second element is whether public access plays a significant role in the functioning of the jury view, and both of those conditions have to apply. Ms. Wagner, through me, advised the court through Jason Frazier some time ago that Ms. Wagner wants to cooperate so that both parties have access to relevant portions of her property that may be important for the jury to see, but made it clear that that access, she has gates that are locked, and she would unlock those gates to permit the court, its personnel, the parties, the jurors, and deputies access of the property, but that she didn't intend to unlock the gates to allow access to third parties, including the media. That's been her position for quite a while now. She had a representative meet with Mr. Frazier and the prosecution earlier this week so they could outline what portions of the property she's cooperated any way she decision, the first test is whether there's a qualified right of access that attaches to the, and there is no qualified right here because it has not been historically open to the public. As a matter of fact, quite the opposite. Thank you, Your Honor.
Mr.
Yeah,
Gardner.
counsel's reading that way too narrowly. The question is whether a criminal proceeding, a criminal trial, is historically open to the press and the public, not whether a person's private residence is open to the public or the press. There would be no, Bronson would be meaningless, utterly meaningless, if the question was whether a particular property was open to the public or the press. The question is whether this criminal proceeding, which encompasses the jury view, is open to the public and press. And criminal proceedings have traditionally and historically been open to the public and the press. So I think that's, my friend is reading that a little too narrowly this morning, I'm afraid.
Your Honor, if I could respond, it says the place and the process. The process is the criminal proceeding. Obviously, when it's held in a courthouse and it's historically open, then you do the balancing test. And but here we don't get there because it's on private property that's been closed, is locked. The access to the property is only gained through the landowner's permission, which has been conditionally granted. But if you look at paragraph 166 or paragraph 12 of Bronson, it says a qualified right of access attaches to a proceeding only if the place and process.
Mr. Griner, since you're familiar with the case, I think you probably were an attorney in the case. What premises were at issue in the Bronson case?
Private residence. There was a murder in that case in a bathroom at a private residence, and that was the place.
All right. I'll now hear from counsel for the defense. You wish to address these issues?
Yes, thank you very much, Your Honor. On behalf of my client, George Wagner, I think there are several problems with the way this is proceeding. One, I don't think this request from the media is timely at all. It's literally on the eve of the jury view, when this jury view has been planned for months. And if the court makes a decision that we're unhappy with, we have no remedy. We don't have time to file an appeal or pursue any other type of remedy if we're not happy with what is done. So this is not a timely request by the media, number one. Two, I've not seen any actual notice of appearance on the court's docket by any attorney for the media, just this letter that was faxed in yesterday afternoon, as I understand it. The overriding interest for my client is a fair trial here. What we don't want to see happen is something on the jury view where the media provokes a homeowner, a neighbor, a passerby, into some sort of incident that the jury witnesses and takes an adverse inference from whatever that incident might be that they would hold against my client because he's the one charged here. And we're one of them. I think this is a joint request for a jury view, but we certainly wanted a jury view. And so my concern is a fair trial for Mr. Wagner, and that we not have some incident involving the media out at the various crime scenes that the jurors witness and cause a mistrial. How many days have we been in this jury selection? Since July 5th or something like that. So one, it's not timely. The property owners have had, one property owner has an attorney here, but there are other properties involved too. I don't know if these people have had a chance to protect their rights as they see fit. The case that the media attorney is relying upon is not from this district. It's not controlling law from the 4th District, and it's not controlling law from the Ohio Supreme Court or the U.S. Supreme Court. So while the court certainly may take it into account, it's certainly not controlling on this court. But we don't want these events to be sensationalized in the media. The court has issued an order that the jurors are not to be photographed in any way so that they can be identified, intimidated, harassed, or anything else. And so if there are cameras out there, there should only be one. The media should have to pull one camera to reduce the risk of capturing the jurors and sensationalizing this in any way. There should be no cell phone cameras allowed from the media to similarly reduce that risk. There should be no aerial photographs whatsoever because those could be enhanced. And if they capture the jury, that's the concern, that they could be enhanced or otherwise misused on social media or otherwise. So our concern is George Wagner's right to a fair trial. Our concern is that this was dropped on us yesterday after spending a month or more selecting a jury. This should have been handled a long time ago if the media had this interest. And we object to the media intruding on the jurors' participation and their viewing of the various things that they need to look at. We think that this is a hornet's nest that's being opened up at the last second, and the court should at least exclude the media from inside whatever security perimeter that the sheriff's office puts into place. Now, the media may have right to public highways, public streets, that type of thing, but there is going to be a security perimeter, as I understand it, set up for everybody involved. And our concern is, with respect to Mr. Wagner having a fair trial, not having some sort of incident provoked by the media, intentionally or not. You know, people react to media in different ways. And these are private homes. All right, some of them are homes of potential witnesses. And certainly, you know, witnesses are sometimes reluctant to testify, and they certainly don't want their homes broadcast. And so we ask that you take all this into account.
On behalf of the state.
Yes, Your Honor. As far as the state's position on this, we know the media obviously has a right to cover the trial. The issue is we don't want anything to happen that could possibly jeopardize a case or do anything to jeopardize the defendant's right to a fair trial on this. We have to be very, very careful. Obviously, the court that we talked about a security perimeter and those things. We don't obviously, nobody has a problem with the media covering this. It just needs to be done in a way where it's not interfering with the logistics of getting out there, showing the jurors or anything like that. There do need to be the restrictions on the no photographing the jurors, which is already in place, and those similar things. I think somebody mentioned aerial devices. If they're not being entirely, those should be subject to the same restrictions as far as you pull cameras in here, no photographing jurors, anything like that. As far as the private property interest, obviously that could be an issue, Your Honor, and we don't want it to be, but obviously we know the private property owners are raising an opposition to the media going on there with the jury view, and obviously we just don't want anything to happen to cause any issues in the case. There could be an incident. We don't want somebody going out there running up saying, get off my property or anything like that. We don't need anything like that at all. So if we could, you have some restrictions, obviously narrowly tailored to fit the facts and circumstances in this case, Your Honor. So, again, that would be our position.
Judge, I failed to mention one point, if I could.
Yeah, I just wanted to add something
Please.
to that. You know, the very first paragraph in your order that you issued is that, let's see, basically that they will comply with any order of this court and comply with all security procedures set forth by the court as well. One thing I would note is that we've taken great care that they are not permitted to document or photograph or video or audio anything that is not on the record in this courtroom, right? And that is because any person from the public could come and sit in the courtroom and they would see exactly what the media is seeing. But in a situation like this, the public is specifically excluded from a jury view. You know, there's not going to be any persons trailing along and being able to view this. So to that end, Your Honor, I would suggest that would, you know, weigh towards excluding the media, but certainly having them, you know, outside of the perimeter of, you know, we had talked about blocking off certain areas when the jury there. So I would think they would have to stay behind those. You know, there's
Judge, just one final point I failed to mention, I apologize, is, I think there needs to be some credentials of the media shown to court personnel so we know who's out there and that they're legitimate media. And so we would ask that the court staff at least know who's out there and check their credentials to see if they are media or not.
Is counsel for either side aware of any violations by the media of any orders we've previously put on concerning media outlet behavior and all that?
On behalf of the state, not that we're aware of.
Judge, the only order I think we're aware of is that we're not permitted really to talk to the media. We've had media contact us, but we don't really contact them back.
All right. This actually is a clarification of the prior order of the court to which Ms. Canepa made. If the media is to enter on the premises, any of these, and we're talking about several places, not just Mrs. Wagner's, but several places and other spots where things are located. If the media enters there, the court does feel that any media person should display proper press credentials, proper credentials showing who they are and who they work for. I'm going to also indicate that in order that the media honor and comply with any security perimeters or rules that the Pike County Sheriff may establish for the security of those jurors and others that are going to be out there. Media is to comply with those and honor the honor and comply with the wishes of private property owners. Because the point that Mr. Parker made is well taken. We don't want an argument ensuing at property on the property that will affect our jury. The media is not to enter any premises that's subject of the jury view before the jurors are taken onto the premises. Any members of the media are to stay behind the jurors at all times, and by behind I mean on the side opposite the side on which is located any premises or structures or objects to which the jurors' attention is being drawn. I don't want the media between the jury and what it is they're supposed to be observing. They need to be on the opposite side. Of course, and if there's any question about that, they can ask the court personnel which side they need to be on if there's any question. I will order that media not photograph. I'm going to say photograph any jurors, counsel, or officers of the court. I'm not going to order just a general no photograph of anything. However, I think that's a little broad, and there's been many photographs taken of many things. So, but the jurors, counsel, and officers of the court are not to be photographed. And I would also say that the owners or occupants of the premises viewed are not to be photographed unless they consent to it. going to order, I think there should be some distance between, we have, as media have been attending knows, you know, we've been trying to provide access, but it's been the back row, I think, back bench. And so I'm going to order that media stay at least 150 feet away from any of the jurors, and media is to have no contact with any of the jurors, counsel or court personnel, except to the extent that they may have a question about interpreting where they need to be and that kind of thing. They may, of course, talk to court personnel about that, ask a question about that. Court personnel, of course, will be expected to direct anyone at the premises where they're supposed to be. But other than that kind of contact, there'd be no contact even with court personnel, because we got a lot of business to take care of, and we have to get it all taken care of in a couple of days. But no contact with jurors or counsel. Does counsel for either side have anything further you wish to request or suggest?
Judge, did you say anything about aerial photographs?
Not specifically, but is that something that counsel's requesting that we have?
As far as aerial photographs, Your Honor, they should be subject to the same conditions as any other order not photographing jurors or anything like that. It's basically just a camera up in the air, so it's really functionally no different.
Is that satisfactory?
Judge, yeah, I mean, our concern is that the jury would be harassed or photographed and then digitally enhanced or shared in some way. So we don't want.
Well, I mean, I said photographing, so that would include aerial photographing. No jurors, counsel, or officers of the court or the owners or occupants of the premises, unless the owners or occupants of the premises give permission to have themselves photographed. And,
Appreciate that clarification, Judge. And
now, this pertains to the jury view itself. This just while we're at our jury view. It is, and hopefully it's tailored narrowly enough to make each side mutually dissatisfied, I guess. But,
Your Honor, just for clarification, you indicated that they would have to comply with any security perimeters or whatever. So they may photograph or whatever from that vantage point, basically, is what the court is.
well, I'm not sure what
Unless they're
security measures the sheriff has put in place. I haven't seen them. I haven't been informed of them. Typically, the court here defers to those responsible to provide security for the manner in which it's provided, unless it becomes onerous. So I don't know what they intend to do. I haven't, but I haven't ordered the sheriff to exclude the press. I would assume they're making some provision out there that they feel is necessary to secure the premises, but I'm not sure what it is.
Yes, Your Honor, we had talked about, blocking off the access points while the jury was out of the vehicle and viewing the properties. We were going to stop traffic on that during that time before the media made their request. So that was already something that was going to be in place just for the security of everybody. This is the public knows that we're going out there. And,
yeah, I understand, and that we're not opening up any of the. I mean, it wasn't the court's intent, and in fact, it's just like the opposite. I do not want there to be an army of people out there while the jury that I've sent out there is trying to view things, I don't want an army of people interfering in any way, or even few people interfering in any way with what the jury's business is. My focus is on the jury's business and providing a fair trial to both parties here, while at the same time making reasonable accommodations to the public's right to know. And so it's sometimes, and I don't think there's necessarily mutually exclusive interests. So hopefully this order will, if properly approached and applied, will do that.
just note our objection on behalf of Mr. Wagner, Judge.
Say it again.
Please note our objection on behalf of Mr. Wagner to any media access.
All right.
Especially.
And the court will enter orders at the scene if necessary, if things get out, if things don't go correctly. So I would expect everybody, but I have no reason right now to believe that things will get out of hand as long as everybody approaches it in the way they've been approaching their access to the courthouse here and here.
Your Honor, just for a matter of clarification, I understood you to indicate that the press was to comply with the wishes of the property owner.
That's what I said.
Also, that occupants of the property are not to be photographed, right?
That's right. Not photograph unless the occupants consent to be photographed.
All right, thank you.
Yeah.
Your Honor,
Yes.
I didn't understand that giving the property owner the veto power to keep the press off the premises entirely. That seems to defeat the point if we're going to do that.
Yeah, I think some of these things are going to just have to be resolved when we go out to we're talking about more than one premises. We're talking about several, as you probably know. You've probably seen so I don't know what we're going to run into. But no, I haven't ordered the press excluded from anything. If we get an exclusion by a private landowner, we'll have to handle that situation as we come to it. What I don't want is an argument in front of my jury that would somehow affect their approach to this case while we're doing that. That's about the best I can say right now. I don't know. I personally haven't seen, I don't know if I've seen any of these places, so I don't know what we're looking at. I don't know if we're looking at roadways in, if we're looking at private, no roadways, I don't know.
Yeah, and, I think the most important, the media will disagree, but the most important part is that our jurors get to view these locations
Yeah.
for their evidentiary value.
Yeah.
We're lucky to be getting on the properties ourselves, I feel, in some situations. So I think that, to expose them, it's their property. I think they can say who comes on and who doesn't.
Well, they can't. That's not accurate. It's part of the court proceeding. They don't have the veto power over it.
You should have raised this a long time ago instead of dropping this on us yesterday afternoon after over 20 days of jury selection.
Your Honor, it is a presumptive right to access. So if there's an objection to access, that is what should have been raised and should have been raised. It's not up to us. So I would just suggest.
Yeah. All right. Well, if there's nothing further at this time, we will adjourn. We have jurors coming in about 5 minutes. They're probably already down there.
You're bringing them up here, though, however, right?
Yeah.
Yes, okay.
Our adjourn.
Thank you, Your Honor.